So
Yes, you.
welcome everybody. We're going to start in just a few minutes. We're giving people a chance to join, and I'm seeing people from Long Beach, Seattle, Virginia. That's so awesome. And I have just we've got a great show for you today. As you know, this is our My Country 'Tis of Thee series in honor of our country's birthday month. And yesterday we talked with AJ Jacobs, who is the author of my The Year of Living Constitutionally, which he did, and that was fascinating. And of course you can see the instant replay video of that because you're all members. And hey, Mindy, hi Colorado, from up the road from you, or maybe down the road from you. Um, but and yeah, it's just been great. AJ yesterday told us, he actually showed us his musket. He actually walked around New York City carrying a musket, and he grew out his beard. He basically lived as if he were in the year when the Constitution was being developed.
Wow.
He joined sort of a militia. He joined a company of reenactors and did a revolution, and yeah, it was very, very interesting. And anyway, he kicked it off. And now today we're going to talk about the tension between the law from a practicing lawyer in the trenches, Jordan Parker Esquire, and what's going on right now and our Constitution. And I will actually start this by saying, and Jordan is the one who brought this to my attention because I had completely forgotten about it. But, I am licensed, even though I live in Colorado, I am licensed in California. And in California now, lawyers who are admitted to the bar have to actually take an oath. We are officers of the court. Hopefully you guys all know that, and we'll talk more about that. But I actually have to pledge to, quote, as an officer of the court, I will strive to conduct myself at all times with dignity, courtesy, and integrity. And I have to wonder whether this was passed because I think it was passed recently, right, Jordan?
Yeah,
Um,
last couple years, I think.
yeah, and I have to wonder if maybe it was. I'm sure it was passed in response to a whole bunch of lawyers who are within the administration and their actions, which are anything but integrous. But I also have to wonder if it was passed because they have to sign on to that, if any of the DOJ lawyers who are being, can I say dick? who are who are being jerks, um, who are not living up to that oath. I wonder, and I haven't looked into this, but I have to wonder whether they set them up so that they could be easily disbarred if they're licensed in California. You have thoughts, I can tell.
Yeah, I, there is case law and such where being uncivil can lead to some kind of discipline or sanctions, but it usually has to be some level of harassment or using
Mhm.
discovery in an abusive way. Discovery being when you demand answers under oath or documents under oath and so forth and so forth. It's very rare for an uncivil lawyer just by being a jerk, just by being what they might call a zealous advocate, but what we may call a dick. And that's
That's a
that's sort of
legal term, guys.
a legal term of art. Yes, yes, yes. Um, Typically speaking, just being uncivil won't be enough unless it's combined with some kind of action. Like at most you'll get the judge that says, please don't do that because the oath is kind of toothless in a sense. It doesn't come with an automatic enforcement mechanism, is my understanding, but there still is case law that predates this that says if you go over the line in a certain way, and typically this uncivilness will not be punished about lawyer to lawyer. It's more if you're a jerk to the judge, for example, like that's more
Mhm.
often where this kind of stuff comes up. Like, yes, if you are committing uncivil behavior in litigation, the court might say, don't, no, no. But if you do anything that undermines the integrity of the court or questions its integrity, then
Right.
you get into contemptuous action or contempt. And that's where it's more likely. Now, to your point, as I recall, John Eastman, one of the fellows who did the one of the 2020 plots, got disbarred out of California. And anyone who's seen him talk
Yep.
knows he's not exactly cordial in his litigation strategy.
Yeah, and also in New York, Rudy Giuliani was disbarred. And yes, those were for crossing the line of integrity or even what is legal. And I guess so that's why I was kind of focusing on that last word, integrity. We have seen in this administration a whole lot of administration lawyers who either they are just so clueless, they genuinely don't know what they're doing, and so have committed what in other courts might be considered malpractice, or maybe they were even doing it intentionally because they're trying to they're under a tremendous pressure to please their overlord. So, but in any event, that's kind of a side. Yes, Ron Eastman is a jerk. That's kind of a side thing. Let's actually get started with our topic, which is lawyers in the courts, in the trenches, and then working that way with this administration, even if you're not directly interfacing with the administration, even if your practice is civil law litigation, just the sort of whole the shadow of what the administration is doing, the shadow of how the administration is attacking our constitution. And as you know, Jordan, and I think most people would expect, you and I, we are actually committed to upholding and protecting our Constitution. And so, to the extent that you have thoughts, and I know you do, on that and what it's like being an attorney in the trenches right now. So, people who don't know Jordan, he is, a friend and colleague. He has a litigation practice, and he's a real live attorney who's practicing right now and seeing what's going on all around him. So, Jordan, what are your thoughts about that?
Well, thank you for asking. One of the things I did before coming on here is I looked up the term officer of the court. So, to have a working definition, and it essentially refers to any entity that has a legal obligation to effectuate the law or advance legal principles, in compliance with the law. And that includes, according to Cornell, judges, clerks, police, and lawyers. Now, lawyers, we like to call ourselves officers of the court. And what that refers to is there are going to be times where your duty of zealous advocacy to the client is going to be outweighed by your obligations to the law. And what that
Yes.
means is you cannot go to court and ask a question of your witness if you know the answer is going to be a lie. You cannot put forward someone that you know is going to lie. You have to correct the record if any of that happens. There are other legal obligations. For example, if the court is reading a case and that case has been overturned by a newer case, you have to bring that to the court's attention so they don't make a mistake. You have a duty of disclosure. You have a duty of integrity. You have a duty to not lie to the court. You have a duty to not put people before the court who also lie, and so forth and so forth. And you see this kind of parallel with other places, like with I mentioned the police. There's a reason why police don't just generally kick down the door and try to arrest you and say, I've got found evidence of a crime. That's why we have a Fourth Amendment. That's why we have a rule that says if you got this evidence without following the law, we'd rather just throw it out because we can't support this. We can't support breaking the law to enforce it. And lawyers are under a very similar obligation. You might be able to win by lying to the court, but you can't actually do that because you're committing a fraud on the court, and you yourself will probably be subject to disciplinary hearings. So whenever people say things about lawyers being dishonest, I would say that's not the norm because we have the state bars to regulate our conduct. People can report our bad behavior and it can ruin our livelihoods. So we have a strict obligation. Not to mention, you as a practicing attorney knows that we have to grind and get 25 plus hours, depending on what state you're in, on continuing legal education, much of which has to include things like ethics. And that comes up all the time.
And people always laugh when they hear that, because they think that lawyers don't have ethics. Because you're right, the public perception in some quarters of lawyers is, that we are a bunch of lying, thieving, you know, what have you. And yet, there's a reason that Shakespeare said in his play, the first thing, "Let's kill all the lawyers."
Oh, such a misunderstood line.
It is such a misunderstood line because most people, well, I'll let you explain it.
It's a great, great line. There's a famous, it was I can't recall his name. There's a commencement address, where a law professor was talking about this thing. And he says, everybody thinks let's kill all the lawyers means ha ha ha, Shakespeare hates lawyers. No, it's actually the opposite because tyrannical regimes, whether you're a king or someone who wishes they were a king, they will go after the lawyers, the people who know the law, the people who know what your rights are, the people who can defend your rights, which is why I've always felt that, there's a lot of people on the internet who are like, I've yelled loudly, I've told people I'm mad. What else can I do? Whereas lawyers might quietly go to court and file a motion seeking an injunction and get it. And that stuff is way more valuable than just panicking on the internet. That's the point of lawyers. We go to court and we get a lot of stuff done. We put the class actions together. Not we, but not we, Jordan, but we, the royal we, the editorial we, the other my fellow colleagues out there that I've never met are doing this. And that's the kind of stuff that really matters. That's the stuff that gets results. And I would say that we underestimate, you've said many times that the resistance will be fought by lawyers, and that's absolutely true. So much of what has been the most effective, not always because, there's a 6-3 majority on the Supreme Court that will rule the way it does, but what has been most effective has been litigating, getting judgments, getting injunctions, getting court orders. And that's why when they say let's kill all the lawyers, what they really are saying, these are the most threatening people to the bad things we want to do because they know
Exactly.
we're not allowed to do.
They're the obstacle, and this is exactly what Trump is seeing now, and has been seeing, and make no mistake, it's one of the reasons that he went after all those law firms and that he, eviscerated the DOJ of honest, hardworking people is because they are the ones that are the obstacle to his implementing all these and we have seen time and again, especially with executive orders, exactly that he issues an executive order and immediately there's a challenge in court and overwhelmingly in the majority of cases, those executive orders are stopped, and it's stopped by who? It's stopped by, well, the plaintiffs, absolutely, but the lawyers, which segues again into what, sort of the theme of this particular show is, which is, practicing law within this administration. And so, Jordan, I know that again that you're not doing federal law as far as I know, but you are a litigator, and I know that you can imagine even if you haven't run into it yourself. We all as lawyers put ourselves in the shoes of the lawyers who are dealing with this. And so can you talk a little bit about what you have seen from the administration in their attempts to barely follow the rules as they to
Sure, I've got some
yeah.
thought. As someone who also went to law school, I'm sure you had picked up some witticisms from your professors. And one thing my criminal law professor at Tulane Law would say to us is, here's a rule of thumb for defense lawyers: is when you have someone on the stand, never ask a question if you don't know the answer, and
Mhm.
never ask a question if you're afraid of the answer. And what you're seeing here with administration lawyers is often they are giving them not enough information to go to court. So you can't lie if you don't know. But the moment they tell them, they have to disclose that to the court. So there's been a lot of what I call strategic ignorance among DOJ lawyers. And you see a lot of them perhaps realized what a terrible position they're in, and just like that famous lawyer who said, "Ugh, I'm so sick of this," or whatever she said, I'm not sleeping, I'm so miserable."
Right. That was in Minneapolis at the height of all the ICE stuff, and yeah, she said I think didn't she say, "I wish that you would sanction me," or
So I can sleep. So I
yeah,
can
so I could just get sleep, yeah.
Right, and a lot of this. comes down to the fact that, I mean, a lot of these lawyers are not in states where there is any civility pledge, and even if there were, they're not following it because, yeah, a lot of them, especially in the commentary, the statements they put out outside the court are very, very combative and very
Yes.
prejudicial, those kinds of things. And then they go to court and they're a little more demure and they're a little more reserved, but still very combative. And you can see this in some of the pleadings they write, which one bit of pressure we often get is the clients want you to put their voice in there. Like if they're very mad, they want you to be mad. That's not necessarily going to win your case. So, you use your judgment. But some of the pleadings, especially, people have joked like this looks like Trump wrote it because there's all kinds of things about how great Trump is in here. And he's revitalized the Trump Kennedy senator, exclamation point, exclamation point. And to me, that's just embarrassing. Like, to me, it would be embarrassing as a lawyer to outsource my work to a person who's not a lawyer just because I'm not strong enough to tell them no. And a good lawyer has to tell their client no, has to tell them, and I do that a lot. I don't just do that for case strategy. Say, if we do what you're doing, it's going to hurt your case. I also do it with prospective clients where a lot of lawyers will take every case that comes their way. And I'm lucky that I'm very busy, but there will be cases where I'll say, I'll take your case. However, there's not a high likelihood of success. You could spend lots of money and get nowhere. I'm just telling you, but if you want to do something, I'll do it. I'm just telling you, you're not guaranteed to succeed. You may just be out of money by the end of it and be where you started. And most of the time, they'll say thank you and then not hire me because I don't want somebody who doesn't understand the risk, because that's how malpractice lawsuits happen, not because we committed any malpractice, but because people are under an impression that if you lose the case, it means you did a bad job. I've seen someone on your thread say that before, saying, "Oh, the only reason people lost is because they had a bad lawyer." I'm like, that is not at all how it works. You can
No.
sometimes just have bad facts. You can sometimes just have a bad judge. You can just sometimes have bad luck. I mean, I work in insurance, and one of the things we have to factor in too, as long as I'm opining on this, is juries are not lawyers, and that's by design. But it also means sometimes they might just go, "Ah, shucks, insurance companies have lots of money. I don't really know how any of this works, but let's just say $500,000." And you got to watch out for that. So all of that kind of plays into litigation because it's not just how the law is or how it works, because we're not practicing in a vacuum. We're practicing with human beings who sit on the bench, who oppose us, and who sit on the jury. And all of that is a challenge because we never win or lose based explicitly on the merits. There are so many outside things that can influence the decision that has nothing to do with any of that. And that itself is very challenging.
And I remember in law school, we had whole classes on jury psychology, and, you do have to take that all into account, but I wanna go back to where you said, that sometimes you will just tell someone, "This is not a winning case," and, you didn't say it this way, but I said when I was in private practice, I would say, "I mean, if you really wanna give me money to go into court and lose for you, I mean, I'll happily take your money." I mean, I wouldn't really, but
No.
but what you know then is that often they will go to the lawyer who tells them what they want to hear and takes their money and then loses. And I always have told, back what for those of you who don't know, I had a practice that was specifically and only for fathers and children where the fathers were trying to still stay involved in the lives of their children, right? They weren't trying to get custody. They were paying their support. They just wanted to not be visitors in their children's lives. And I would always tell them, "Look," because it was a very challenging area in which to practice because this was many, many years ago, and the courts were very biased against men at that time, and I would tell them, "Look, I will never tell you what you want to hear. I will always tell you what you need to hear." And, I mean, they really appreciated that, but I learned early on they needed to hear that right up front because they needed to be able to distinguish because they would go to other lawyers who would be like, "Oh, yeah, I'm gonna get you joint custody," and which was almost unheard of back then, and I would say, "Well, no, that's pretty unlikely, but we will get you more time with your kids. But the point being is that that's the other element of that, in addition to the juries and the judge and, the witnesses and all the other people, it's the expectation that the client has. And speaking of those lawyers, I know you wanna say something, but again, to bring it back, those lawyers who are the ones that are the yes men and women, the ones telling who are inclined to tell a potential client what the client wants to hear, those are the people who are left in the DOJ now. And those are the people who, as you said, some of them don't even have all of the information, and whether that's by design, as you suggested in some cases, because if you don't know, you can't lie about it, or whether it's because, I mean, we've just seen some pleadings coming out of this administration, at the trial court level, which is the level at which you work as well, that, I mean, just and some of my notes from front members, when they get those documents, they see it too. It's like, if as a lawyer, I would be so embarrassed to stand in front of a judge and have them ask me a question and have me say, "Oh, I don't know," or "I didn't know that." I mean, it's just mind-boggling.
Well, there isn't a form of measurement for the amount of lawyers and people working for this administration who are willing to debase themselves for Trump. That's just whether you are a cabinet official or a DOJ lawyer. These are people who believe in the cause or want the experience and are willing to just be humiliated by he shouldn't be technically their boss, but that's really where they treat it as their boss.
Mhm.
And a big challenge with all of this is you're right. It's embarrassing for them to go to court and to make arguments that, like, I don't ever want to go to court and make. I don't ever want. I mean, I don't even I don't want to put anything in a pleading that is an argument that's beneath me. But I also want to add something. I'm lucky enough to practice with my brother, and he has a line that I live by, and it is in the practice of law: under promise and over deliver. So that means don't promise the moon and the stars. So if you get more than you're expecting, the client will be happy. Trump does the exact opposite. He promises the sun, the moon, the stars, and the entire universe about everything, which is why he rules by executive order. When if they had, you know, there's an argument that with birthright citizenship, if he had done an executive order that said only temporary visa holders or people here unlawfully, it might have been a closer case. But because it was as my understanding, it was such a wide-reaching order trying to overturn the 14th Amendment by executive order, the court just didn't have an out to go with, so they issued a much broader decision. And in fact, the Wall Street Journal criticized Trump just for that, saying if you had a limited order, you might have been able to do this. But no, you have to do it. You have to be the man. You have to do it like this. And if they had a little more discipline, or if he had someone to tell him, actually, this is not calculated to succeed, we might actually get really bad precedent out of this. And he's like, no, let's do it.
So let's stop on that for a minute, because that is a great example of one of the things that we're to be discussing today, which was that was a direct attack by the president on our Constitution, on one of the amendments. And so can you just talk a little more about that, about this administration, and then the lawyers who are committed to protecting the Constitution? Because that's a great example of that very tension. And I have to be honest with you that I can't even really listen to the oral arguments at the Supreme Court when John Sauer is, I think it's John, right? Sauer
Yes.
is talking, because he's attacking our Constitution, and I don't understand, as a lawyer, I don't even understand how he can live with himself for doing that. But let's not talk about, I mean, that's just like one guy, but if you could talk more broadly about that tension of this administration attacking our law. I mean, laws are one thing because they are passed by the Congress and they are open to being changed, but But an administration that is literally attacking our very Constitution, and then the lawyers who have to, A, defend the Constitution, but also B, who have to somehow support the attack on the Constitution. I mean, have you ever thought about being one of those lawyers? I don't mean have you ever entertained applying, but have you tried to put yourself in the mindset of one of those lawyers? And as a practicing lawyer yourself in the trenches, what does that even look like?
I I think a lot of people like to comfort themselves with this idea that these lawyers are tortured. You know, they're like, "Oh, what do I do? What do I do?" When the reality is probably worse, which is just they want to do this. They I don't think a lot of the I think the ones that are left are the yes men, are the people who are happy to do this, are the people who were a strict constructionist on Tuesday and then a loose constructionist on Wednesday, depending on what the case is. And when I refer to loose constructionism, what I'm referring to is their conservatives for years have criticized, the more liberal interpretation to say, oh, the Constitution is living and we have to adapt to changing things. And they're like, I hate all of this. It has to be, it's whatever they said at the time, that's what it means. And then with the 14th Amendment, they were very much like, there's this great exchange where a lawyer for the government was saying, well, the Constitution, they never considered all these illegals coming into the country. And then Roberts retorts, yes, but it's the same Constitution, isn't it? Saying that like, that's not my problem. That sounds like a policy solution. If you don't like it, you should do something about it. And I think what was so concerning to me about the birthright citizenship case is now another thing I was told by a pithy law professor was for all of the pomp and circumstance and all the, prestige we give to the Supreme Court, the law is what five people in robes say it is. So we can say it's an attack on the Constitution, but it was also one vote really away. It was reported 6-3, but it was really 5-4, as I understand it, we're in favor of the Constitution saying what it says. Because all it would take is one more justice to say, actually, the Constitution doesn't say exactly what it says, and 100 years of precedent needs to go. And that's really the problem, because as lawyers, we try to not demean judges. We try not to be like, oh, that's a partisan hack. But, you know, not all judges are smart. Not all judges are not all judges have a coherent judicial philosophy. A lot of them play judicial Calvin ball, for anybody who's familiar with the Bill Watterson comic about Calvin ball, referring to just making up the rules as you go along. And with respect to this, you asked, what do you think about the lawyers? I think they want this. I think they absolutely believe that the Constitution says what they want it to say. And they want to push this court because they have a very cynical view. You hear Trump talk about it, saying, I appointed three of you to the bench. You owe me. And that's not how it's supposed to work.
Right.
And that's where we're at a point where his own sort of barnstorming of the court and sort of saying out loud the kind of cynicism that we only just suggested before is making it so people don't trust the Supreme Court like they used to. Don't trust its deliberations. I'm sure you could go at length about this more, but the idea that, oh, it is, we have to allow a president to fire heads of executive agencies, and the law saying that they need good cause constrains his power. Well, what about the Federal Reserve? Well, obviously that's different. Why? I don't know. Because
We want it to be.
Principled, logical reasons.
Yeah. No, I see that, and I have to say that that's true, and, I think you also really brought up an important point, which is, I don't believe in our history now, there have been many instances in history of presidents going so far off the rails as Trump has,
Yeah.
and mostly it's been, individuals who have made the difference. The most recent one being Nixon and, oh my gosh, and Ellison, right? Isn't that one of the reporters who broke Watergate? Dan
Well, I know
Ellison?
Woodward and Bernstein. I don't know if there was other people,
Okay,
but but yeah, Washington.
they wrote it up, but I think it was Ellison who was anyway, the point being it was actual individuals who have started the movement that would rein these people in. Frederick Douglass also, I mean, he was very influential, um, and my point is just that, Trump is by far not the only one to have gone that far off the rails. I mean, heck, Adams, like, is the one who first used the Alien and Sedition Act,
Right.
right? Um, but I think in all that history, and I could be wrong, but I think that no other president has so blatantly shown that he believes he can pull the strings of the Supreme Court justices that he has appointed.
I think there's some truth to that. I want to be careful about making too broad of a statement on that. Because you could look to be fair, you could look to, as I recall my AP US history, FDR didn't like it that the Supreme Court was ruling against his initiatives. And while there
Right.
was never really a court packing plan presented, it was sort of floated like, well, maybe I could do something. And then by coincidence, the Supreme Court suddenly is like, wait a minute, my precedents from 2 years ago are slightly different. So we really have to be careful. And you're very good at this, which is sort of letting people know that yes, we live in both unprecedented times, but they also have happened before. And we have to be careful when we're like, well, obviously the people who I align with ideologically more are angels and the people I disagree with are devils. And that's not true because a lot of
Right.
where we are bring congressional power to the executive. They come from people pushing to try to force constitutional changes through the court that they couldn't get at the ballot box. This is a thing that
Yes.
happens, and you didn't mention this. Good, you've mentioned him before. Woodrow Wilson in World War I was absolutely cracking down on political opponents of the war, and some of our worst First Amendment jurisprudence, like the can't yell fire in a crowded theater, one of the most horribly misquoted cases came, as I recall, out of that era. I think that was Schechter or Schenck, maybe. But yes, we have to be humble about the fact that where we are does have precedent because everybody's the hero in their own story. Everybody believes, yes, I may be bending the rules, but I'm doing it for a good reason. Oh, well, if you have a
Mhm.
good reason, obviously, like, George Bush just wanted to protect the country. Who cares about civil liberties? Or, well, Woodrow Wilson just wanted to protect us war dissenters. Or John Adams just wanted to protect his ego. I mean, reasons, good reasons, you know, it's challenging because there's a comedian out of California. He has this great quote. This guy named Mike Fellows, very funny guy. He has this quote that I've seen on T-shirts because people stole it from him, and it says it's a joke, but he says my favorite conspiracy theory is that everything is going to be okay, and we have this sort of I know we have this normalcy bias where because we live here and we've gotten through stuff, we think we're always going to get through it, and long term, like thousands of years, yes. But right now, we don't actually know. We control our destiny. We have the ability to shape this stuff, but it behooves us to not only fight for what we believe in, and this is key, be honest about how we do it, which means point out when our own side or making bad arguments. Tell your client whether it's a literal client because you're a lawyer or your political compatriots, actually, this is a bad argument, or actually, this is false, or actually, if you make this argument, we will look bad. And we have to do that because there are people who view their clients as I am your tool, I will do what you ask me to do. But a good lawyer and a good political leader and a good so forth will tell their people no. And a lot of people don't like that. And I want to circle back to one thing you said. Why do people have all these negative views of lawyers? My theory is because a lot of those lawyers become congressmen.
Well, that is true that most of the people in Congress were lawyers. Yeah, it's an interesting theory. An interesting theory. Also interesting though is that Trump is not a lawyer,
He is
and
not.
a vast majority of the people that he has appointed in his cabinets and to the various to heads of various agencies may or may not be lawyers, but a large number of them have almost no experience in the sort of position to which they have been appointed. The most recent, I think he's the most recent, is Bill Pulte. Uh, uh,
Yeah.
I mean, it just boggles my mind. Um,
I would say the less you know, the more you can be manipulated into it. I mean, what was it? Like, no disrespect to plumbers, but I'm not sure to what extent Mark Wayne Mullins' experience in the UFC and having a plumbing business makes him able to run, the third largest government agency, DHS. But we've come to a point where a lack of experience, whether running for office or being in government, is somehow treated as like, you'll do great. It's sort of like that. There's a New Yorker cartoon of someone being like, who wants, like, this smug elitist pilot thinks he can fly better than all of us. I want a, real American who can, salt of the earth person. And a lot of this struggle that we have is we've started to view experience as sort of a negative thing, as like, I mean, I remember living in Oklahoma and having a political/legal discussion with someone, and at a certain point I started to get frustrated. I'm like, look, man, I'm a lawyer, you're not. Can you maybe just consider the fact that I have more experience interpreting the law? I'm telling you this statute says what it says, and what you're saying is wrong. And then he tells me, and a thing that still upsets me is like, well, I mean, no one person can possibly know one thing more than the other. Nothing. And basically saying nothing is knowable. There's no such thing as expertise, and that is a huge problem because everybody is doing their own research. And this is why I get annoyed when people, especially of the liberal side, say it's not my job to educate you. Oh my God, yes it is, because we know what happens when you leave people to do their own research. If you actually know something, tell it to someone and
Yeah.
cite sources.
Hey, so we have a question from the audience, and Ron is asking, how much say so do the state bars have in ensuring good ethical standing?
That is a great question. So, a lot of people don't know this, but it's not just that the court will, that the state bar will give you ethical rules you have to follow, that you have to do 25 hours of continuing legal education, including like 4 hours of ethics every couple years. But you could actually go to law school, pass the bar, and not get admitted to practice because you have a long criminal history or you have a whole bunch of ethical lapses that would prevent you from practicing. So they can block you from even being admitted to practice if you have a criminal history that you didn't disclose or you do disclose and it suggests you can't do your job honestly. So they can sanction you for unethical behavior. They can order you to do ethics training if you behave unethically. So there is a lot of things that the state bar can do to regulate the practice of law, something that more of us have become aware of as Trump attorneys keep getting disbarred because they just can't, they just want to do crimes. So, I mean, it's like that. I don't want to curse. So it's like that line from Liar Liar, stop breaking the law, bleep, just, but pivoting back, the state bar controls how we practice and we can be reported, we can be punished, we can be sanctioned, we can even be suspended or disbarred for behaving unethically.
And to add to what may be a follow-on question, which I will answer without it even having been asked, in order to practice at the federal level, you must be admitted to at least one state bar or the District of Columbia. What I don't know, I haven't seen happen yet. It doesn't say it hasn't happened, but I haven't seen it, is whether anyone in the current DOJ has been disbarred in their single state of license, and if so, if they actually stopped practicing at the DOJ. And it's also important to understand that the practice of law, there's a lot of different rules about what that actually means. So, I mean, the very clear-cut example is you cannot go represent someone in court if you are not admitted and have a license to practice law.
Unauthorized
But
practice of law.
right, exactly. But there are things you can do even if you don't have a license because they're based on your own knowledge, and as long as you're not representing someone or submitting it to the court. I mean, so I guess my point is there may be disbarred attorneys now at the DOJ, but they're working in the background, just, doing research and writing or something like that.
Well,
I don't know.
we have you know, one of the best things about, I come from a family of lawyers and doctors and so forth. And one thing about doctors is they say, You've gotta be nice to the nurse staff because they run everything. And a little secret about the law is paralegals
Yeah.
run the office. They get stuff filed on time. They remind you of deadlines you've forgotten. They are people you do not want to piss off because you need them to do their jobs and you need to let them know they're valuable. I mean, one of my law firm I used to work at, I saw a 50 something paralegal break down into tears because her supervising attorney was screaming at her. And when you see a full grown adult woman cry at the office, I mean, you can't help but go, What are we even doing here? Like, how do you think that this is the best way to achieve what you want? And I think this is problem among doctors who treat nurses like, oh, well, I went to medical school and you didn't. And there are lawyers who like, I went to law school and you couldn't. But, you know, our opportunity or our achievement doesn't make the achievements of the people who help make this happen less. It makes them more. We are all,
Yeah.
every part is necessary to make this machine work. It doesn't matter how it got there. And too many people forget that those people also have lives outside of the office. These people have families, these people have feelings. And way too often lawyers forget that because there's a joke that, oh, the paralegal is at fault for everything bad we do and not at all responsible for any good thing we do. And I always make sure to tell legal assistants or paralegals that what you do matters. I couldn't do this without you, and thank you. And if you forget that the people who serve you loyally in the office are doing their job and but need encouragement, if you forget that, you're going to be in trouble because you're going to cause burnout, you're going to cause staff turnover. And believe me, at that old law firm, that one lawyer's paralegal was vacant like every 3 months because she kept driving seasoned professionals away. And that's not okay.
Right, right. So let's circle back to the Constitution because this is, again, our the birthday month, and that's what we're talking about. Um, when I'm trying to figure out how to formulate this question, like I want to ask you, like in my practice and in what I do now, I am constantly thinking of the Constitution. No, well, not constantly, but it comes up a lot, and I think that people probably now are more aware of how their own individual lives are actually touched by our Constitution, uh, but I think lawyers are see that in a different perspective, and so what I'm wondering is, in your own law practice, where do you if you do see I don't mean to put you on the spot, but are there places where you actually cognizantly think, "Hey, this is the Constitution coming into play?"
That is a very, very good question. I'm not in criminal law, so things like the Fourth Amendment doesn't really come up, for example. But in terms of jury trials and the right to a jury trial, and people, defendants typically have a right to select judge or jury, and being able to have your case heard by a jury of your peers is one of those things that's incredibly important because I never really know why people choose one or the other, but having being able to convince 12 strangers, who are maybe less plugged in on the law, might be able to see your whole story. They might want a jury. Other people might say, this is so technical. I want a judge to hear it because I don't trust the jury to get it right. And so that for starters comes into play. Another thing that comes into play is the First Amendment. As many people have covered, there's something known as anti-SLAPP lawsuits, and in fact, Trump is famous for getting hit with anti-SLAPP lawsuits or anti-SLAPP challenge. Now, that's
Can you explain what that is for the
yes,
people?
it's called the strategic lawsuit against public participation. Essentially, you are not allowed to sue somebody if what you're doing is punishing them for exercising free speech rights. For example, if I file a good faith lawsuit against somebody and somebody countersues me for harassment, then I would probably file an anti-SLAPP lawsuit because I'm like, you're trying to punish me for using my legal right to petition the court. Or if somebody, and Trump famously in 20, like back when he was just an annoying, person on the internet, famously said to Bill Maher famously made a joke about him saying, like, if he can prove that he's not the child of an orangutan, then I'll give 5 million to charity. Obviously a joke. He said, no, no. And then he put out his birth certificate. See, my dad wasn't a monkey, and sued, trying to claim this was a breach of contract. And this was, I think, a case that was kind of pushed by, his fixer, Michael Cohen, but I was embarrassing because I think it was a big time law firm that represented him. I think it was Cooley. And at a certain
Ah,
point, there was pushback and they voluntarily dismissed the case. And everyone's theory was he was going to get hit with an anti slap motion because this was very obviously a joke, not a contract. And if you get hit with an anti slap lawsuit, you can be forced to pay attorney's fees. So I think of the First Amendment there, like you're not allowed to sue somebody just to harass them. You're not allowed to sue somebody just to bleed them dry, especially if you're retaliating against them for speaking out against you. And you will see, and I've seen that a lot, and I have defended against anti-slap motions and won them. It's a very easy motion to file, and when you win, it's really great for your client. And if you lose, then the case goes on.
so what I'm hearing is that you are, maybe not a lot, but you're dealing a fair amount, with actual First Amendment issues,
It
right?
certainly it
In the
certainly has
slack.
come up. It certainly comes up, especially in the anti-SLAPP field, where you have to either push for an anti-SLAPP motion because you say there's no actual relief here. You are trying to sue us for protected expressive conduct, like filing a lawsuit or being critical or so forth and so forth. And there are strict rules and all of that. But this kind of brings me back to one of the frustrating things about the law that I wanted to talk about, which is that people don't realize that the law is written for people who act in good faith, which means that if you act in bad faith, you can use those in the exact same way. For example, if the government were to charge Jordan with crimes, you can be damn sure I would like my due process and all kinds of things and the right to file every motion. And people were very angry at the DOJ and the last administration for what they say was dragging its feet on prosecuting. And the challenge is that the due process that's afforded to Trump is necessary, but we don't really have a system that knows how to distinguish, you know, saying, "Oh, this is just to run out the clock." Well, that's their right. It's their right as due process to file to file appeals, to file evidentiary or discovery objections, and so forth and so forth. We don't really have a method to separate good faith and bad faith unless it is tortious, meaning a crime or abusive discovery or so forth. And it is very, very challenging because if you were to cut off those due process rights and say, I want a trial in 3 months, well, guess what? This government might be doing that to you and forcing you into trial before you're ready. So the law is a double edged sword and it really depends on who's wielding the weapon. All we can do is try to set some guardrails for bad faith behavior. And it's not always going to work in the way we'd like, but we err on the side of give people time, give them process, give them the opportunity to contest these things. Because justice, one way or one person's justice is another person's crime. And you need, or injustice, and you need to give people the time to litigate and the time to do this. But it's so challenging because unless you can prove somebody is doing abusive or harassing conduct, pretty much everything, a lot of the stuff is okay.
And, I mean, I think so at least my members who are here will know that just today I sent out, uh an article about a case where just to prove that it's not even always foot dragging, right? I mean, sometimes the courts are either just backlogged or it's very, very slow, having nothing to do with the parties. And a case in point is this article I sent out today about a Fourth Circuit decision that was based on the CIA basically furloughed several employees at the very beginning of 2025, immediately following Trump's executive order on DEI. And they basically said, "We're putting you on leave, and we are basically, we're probably gonna fire you." They were, in line to be fired, and all of those employees were the people who worked on DEIA specific projects for the CIA. And you, like I, may be wondering, like, well, what would be a DEI project for the CIA, but these are the people who made a point of going out and, recruiting and otherwise, interacting with people from different cultures and from different walks of life because, it's important, or at least it was important to the CIA to have a well-rounded pool of agents and officers from all different, again, walks of life and countries and those sorts of things. And so they filed a lawsuit, and one of their claims was, uh, due process because they didn't get an opportunity to even, appeal the decision or talk about the decision or ask to be reassigned. They just were, boom, you're on leave now, and we're probably going to fire you. Uh, but another one of their arguments was this First Amendment claim, and this is just to show, how the First Amendment can touch so many different things, like some of the things that you talked about, because they said that the CIA had assumed that they had a certain mindset about what was going on domestically, and so therefore it wasn't in line with this current administration's thoughts on, you know, domestic stuff. I mean, so basically it was the CIA being the thought police, and of course thoughts, I mean, and speech are protected by the First Amendment. But my whole point in bringing this up was they filed that lawsuit in February of 2025, and the court gave them an injunction in March of 2025, and the administration appealed it to the Court of Appeals, the Fourth Circuit, in May of last year. Did nothing else. There was no other action from any party. It was just there in the Fourth Circuit, and oral argument didn't happen until December. And then the opinion didn't come out until last week. So that is a year that these people were all just like, "Okay, well, we're sort of in, on hold." So sometimes it just takes a really long time to get to the point where the court, especially at the appellate level or the Supreme Court, uh, for the case to get there and to then be heard, because oral argument has to be scheduled and the justices have to review everything and they have to consider everything after the oral arguments. And so it just, this is a tangent because you weren't actually talking about the wheels of justice turning slowly, generally, but I know people have been really frustrated about that. And a lot of times it's not the administration even dragging their feet, although in this administration it is. Um, but it's just that again, the wheels of justice turn slowly, and it's because you have to be very careful, as you alluded to. You don't want a rush to judgment. Like literally, that there's the term rush to judgment. You don't want that.
It's true. One of the big problems we have practicing, in California is everything is just so damn backlogged. So you might have, and one of the things that I took a couple years off of practice because I got disillusioned. And one of the things that frustrates me is the practice of law is so different from what you want it to be. And an example of which is just getting basic motions before the court is a Herculean challenge. I can file a motion saying, I'd like to amend a pleading. Like, when can I see you, judge? How about January of next year? No. So then now we have to file an ex parte, meaning we tap the judge on the shoulder and talk to them privately. We have to file a separate ex parte motion to say, hey, can you shorten the time? And you're like, ah, shucks. Yes, I can, because you asked me, which is frustrating to someone like me because I'm like, well, why couldn't you just hear me now? Why did I have to go to court twice to get you to meet with me? But it's because they are drowning in work. And that's why one of our strategies when we write briefs is assume the judge has read 1,000 pages of nonsense and they're tired, and just give them the bullet points right at the beginning. Tell them exactly what you want, what you need. Assume you've got everything in the introduction and they don't need to read any further. And you can't account for the fact that a judge just might be tired. A judge might just be drowning in stuff. They might have stuff going on at home. You don't know. So you have to draft your things for that. But yes, the delays in court, that is not necessarily an executive consequence of this administration. that is just there are too many damn cases and not enough judges, and nobody wants to pay to make more judges, whether it's federal or state or otherwise. And when we're talking federal, there are strict limits to how many judges there are, and we've seen this too with immigration. That's by design. That's a whole other animal here, where they are just firing immigration judges and creating backlogs on purpose because they don't actually want to faithfully execute the law in many cases. Immigration law is a very good example of that. This is a issue of where if you're too qualified for your job, they don't want you. They don't want somebody who will view this stuff with the kind of ethical rigor that is required.
Oh,
And this isn't
absolutely.
fastest version. This is just going off of what they do. That seems to be what they're looking for.
Yeah, no, that's absolutely true, and actually, I'm glad you brought up immigration because, Friday, which is the last day of this series, we are going to be talking about the immigration experience with both an immigration lawyer and then separately with, I believe that we have this firmed up, Zev, Shalev, who is going to talk about his experience of having, always wanted to come to the United States because of how wonderful it was, and then got here in a time when immigrants were treated very differently than the expectation. Uh, but I also want to mention, well, first of all, I want to say, back in California, we had this judge. She was just absolutely phenomenal. She was such a great judge, and she was on the family bench, and she did a video of herself talking to the people that they had to watch, that the parties, like the parents, had to watch this video before they could get into her court. And in it, she said, "You know what? You don't want me making these decisions for your family. You want to be able to come up with something between the two parents about, custody and parenting time. You don't want some stranger because you know what? I don't really care. And you don't know, I might have had a fight with my partner right before I came to work today, and I'm in a bad mood." And she was amazing because that was also true. And you rarely hear a judge say something like that. So, plainly. But we have a couple of different questions, so still, and I know we're at the top of the hour, but, Ron, can a disbarred lawyer appeal to its state bars and have it be reinstated? I think it's different from state to state, but certainly in some states. Is that your experience?
My understanding, yeah, because I know Eastman appealed as far as he could to say this was, politically motivated and not constitutional and all kinds of words, but yeah, due process is due process. It would be bizarre if the state bar regulating lawyers was the one place where you're like, no, sorry, you're not allowed to appeal. You're not allowed to do any of this. As I recall, Giuliani and Eastman did appeal all of this stuff. So yeah, you can appeal and try to be reinstated, but there are cases where you are permanently disbarred, where like you can never ever practice. A lot of times it's just a suspension, but there's also sometimes they're like, nope, this is too far. It's like from Better Call Saul, Chuck McGill saying giving a certain lawyer, giving certain people a law degree is like giving a monkey a machine gun. We do not trust you to wield this properly, and sometimes the court will make that decision.
I think I would trust a monkey with a machine gun more in some cases. But and then just to wrap it up, so Rose Lady asks, "Is it moot that the Supreme Court says that Trump can fire anyone?" Is that the CIA case that we just talked about moot? My reading of that case is that it overturned just decades of precedent of from a case way back when called Humphrey's Executor. But my reading of that case is that that specifically is about whether the president can fire the head of an agency, and it doesn't trickle down to his minions then firing lower minions. But Jordan, I don't know, you may have a different take on that.
No, I've had some experience. I have very limited. I did handle one matter involving termination of a federal employee, and in that case, we learned that there are very specific civil service protections that say you can only be fired if certain procedures are followed and if there is pretext for removing somebody. And these are stronger protections than, say, the ones that are limited by you can't fire someone for race or age or otherwise. That you have to have cause. You can't, there are, in most cases, a lot of federal employees are not at will. They have union contracts or they have other things. So yes, uh, The reason why the Supreme Court ruling is different is because one is saying the president has the power to fire top level officers who run agencies. The other is has separate laws in place that say we need federal civil service protections that are strong and they serve the public policy of making sure that people do their jobs and they're not, you know, terrified into breaking the law because they might be fired or otherwise. So there, and just the fact that civil service protections are helpful in a place where you have to effectuate, you know, an employer as large as the government. I forget who said it, but someone once said the US government is basically an insurance company with a standing army. And that's kind of,
Ah, um, well, yeah, so I think so the answer, Rose Lady, is that Jordan and I both agree that it is not moot because that Supreme Court ruling was specific to Trump being able to fire the heads of agencies versus, you know, the lower level civil servant who has some statutory protections. So, everybody, first of all, thank you so much for joining us. This week so far is just so much fun and it's been so enlightening for me. And I hope you will join us again tomorrow. I'll give you the lineup in just a minute. But first, for any of you who are here from me and you are not yet following Jordan, you absolutely should. You can find him at The Stand Up Lawyer here on Substack. Please follow him. And for you people who came over from Jordan, I would be honored if you would follow me. You don't have to, but I would certainly be honored. Tomorrow, we will be talking with Danielle Rafe, and she is a retired American diplomat with USAID. So we're going to talk with her about that. And then Thursday, we have Jesse Wegman, who is with he's a senior fellow, in fact, at the Brennan Center for Justice, and he's also the author of The Lost Founder, the founder who people never have heard of. So that's going to be super interesting. And then again, as I said, on Friday, we're going to be talking about the immigrant experience. We'll be wrapping up our My Country 'Tis of Thee live interview series in honor of our country's birth month. So everybody have a tomorrow it's at 4 p.m. Eastern. It's not always at the same time. But of course, I'll send out reminders tomorrow as well. So thank you again for joining us. You will be able to see the instant replay video of this, I think, within the hour. And just have a great rest of your day. Thank you so much, Jordan. Thank you. It's always such a pleasure. Just talking with you. It's really
it's so
enjoyable.
nice. It's so nice to see a friendly face, especially when that friendly face is yours. And I also
Thank
tell
you.
anybody who's following me, who happens to be here for me, please follow Anne. In a world where people are focused on chasing headlines and clickbait, she's the one who says, hold on a second, let's get this right. And
Thank you.
I appreciate the work that she does and that she is particular in the words she chooses and the things she argues. So credibility is a tough thing to build, and I think she's done it, and I'm very appreciative of it.
Oh, that's so kind of you. Thank you. And also, one last thing, guys. When you see the article or post, whatever you want to call it, that comes out about this with the instant replay, if you could please leave us comments letting us know what you thought about this conversation. That would be very helpful for us. So, okay, well, bye for now.
Bye for now. Thanks for coming.